Hey, everybody. Lots of conversation out there about mandates and what employers should be doing or not doing for that matter. And what I've been noticing in these conversations is there's not a lot of reference to how the courts have actually been ruling over the past 12 to 18 months. And I think it's very important for employers as they're discussing things with their executive team and with legal counsel that they know how the courts have been ruling, because that's more than likely going to point the way to how they will rule in the future. Precedent, when it comes to our courts, is very important. And so, what I want to do is make sure that employers are aware of two very recent cases. One, Bailey's Campground v. Mills, which was a decision out of Maine, and Butler County v. Wolf, which was a recent decision from Judge Stickman out of Pennsylvania. It's very important for you to both know those cases so that you can have informed decisions moving forward. So let's dive in. The case of Bailey's Campground v. Mills centered around the mandate from Janet Mills, the governor of Maine. And the mandate stated that anyone traveling into the state of Maine needed to quarantine for up to 2 weeks. A suit was brought by Bailey's Campground stating that that violated the constitutional liberties of citizens. And in that case, the governor of Maine was arguing that because there was an emergency, the COVID-19 pandemic that was facing the state, that imbued the governor with powers that were very similar to the powers that were given to the state of Massachusetts back in the early 20th centuries in the Jacobson v. Massachusetts Supreme Court decision. Now, for those of you who are not familiar, that court case centered around a smallpox epidemic in Cambridge, Massachusetts in 1902. The Board of Health stated a ruling that every citizen needed to get a vaccine or pay a $5 fine. Henning Jacobson sued, basically stating that this violated the due process clause of the 14th Amendment. Now, he was overruled by the state Supreme Court and the Supreme Court. But interestingly enough, the state Supreme Court in this famous case that supposedly gives and grants the ability to force vaccination said this: if a person should deem it important that vaccination should not be performed in his case, and the authorities should think otherwise, it is not in their power to vaccinate him by force. And the worst that could happen to him under the statute would be the payment of $5. So it's very interesting that the state Supreme Court, before this was kicked up to the Supreme Court, made it very clear that it did not view this as a vaccine mandate. So Jacobson, even though it's referenced quite a bit as an example of the types of emergency powers granted to the government, is something that is more restricted than some people actually give it credit for. But in the Bailey's Campground v. Mills case, it was referenced a lot from the governor as a means of demonstrating that it actually has the constitutional right to implement something like a quarantine. But the court said this: the permissive Jacobson rule floats about in the air as a rubber stamp for all but the most absurd and egregious restrictions on constitutional liberties, free from the inconvenience of meaningful judicial review. In the 11 decades since Jacobson, the Supreme Court refined its approach for the review of state actions that burden constitutional rights. And then it cited Planned Parenthood v. Casey. And in Casey, the Supreme Court said something very interesting. It was affirming Roe v. Wade, but then also making a further judgment. Roe, however, may be seen not only as an exemplar of Griswold liberty, but as a rule of personal autonomy and bodily integrity, with doctrinal affinity to cases recognizing limits on governmental power to mandate medical treatment or to bar its rejection. If so, our cases since Roe accord with Roe's view that a state's interest in the protection of life falls short of justifying any plenary override of individual liberty claims. Then the court went on to cite an article from the Harvard Law Review, which I would highly recommend any of you read for yourself. But I'll highlight just a short clip because it ties back to the tiers of scrutiny that we just discussed. Indeed, as Professor Ilya Somin has put it, imposing normal judicial review on emergency measures can help reduce the risk that the emergency will be used as a pretext to undermine constitutional rights and weaken constraints on government power, even in ways that are not really necessary to address the crisis. Otherwise, we risk ending up with decisions like Korematsu v. United States, in which courts sustained gross violations of civil rights because they are either unwilling or unable to meaningfully look behind the government's purported claims of exigency. Korematsu v. United States is widely regarded as one of the worst decisions from the Supreme Court, but in a very powerful and chilling dissent, Justice Jackson said this: "Once a judicial opinion rationalizes such an order to show that it conforms to the Constitution, or rather rationalizes the Constitution to show that the Constitution sanctions such an order, the court for all time has validated the principle of racial discrimination in criminal procedure and of transplanting American citizens. That principle then lies about like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of an urgent need. Every repetition embeds that principle more deeply in our law and thinking and expands it to new purposes." In referencing the Harvard Law Review article, the court in Bailey's Campground v. Mills was not being too shy or vague about the fact that it felt that there was a violation of the constitutional rights of citizens who were being required to be in quarantine, even if there was no proof that they were infected. And Bailey's Campground would be referenced later that same year by Judge Stickman in the ruling against Governor Wolf in Pennsylvania. Now, for those of you who are not familiar, the ruling in Pennsylvania was against the stay-at-home order and the ruling that no groups of a certain size could meet indoors throughout the pandemic. And there was a lawsuit brought against the governor at the time. Now, Judge Stickman in his ruling said the following: "Ordinary constitutional scrutiny is necessary to maintain the independent judiciary's role as a guarantor of constitutional liberties, even in an emergency. While principles of balancing may require courts to give lesser weight to certain liberties for a time, the judiciary cannot abrogate its own critical constitutional role by applying an overly deferential standard." Stickman then went on to cite the closing argument from the Jacobson Court. Now, keep in mind, this is the very decision that is being used by governors to uphold the deferential standard for constitutional review. But at the closing of that very case, the Supreme Court said very clearly, "Before closing this opinion, we deem it appropriate, in order to prevent misapprehension of our views, to observe, perhaps to repeat a thought already sufficiently expressed, namely that the police power of a state, whether exercised directly by the legislature or by a local body acting under its authority, may be exerted in such circumstances or by regulations so arbitrary and oppressive in particular cases as to justify the interference of the courts to prevent the wrong and oppression." After citing Jacobson, Judge Stickman went on to say, "There is no question that our founders abhorred the concept of one-person rule. They decried government by fiat. Absent a robust system of checks and balances, the guarantees of liberty set forth in the Constitution are just ink on parchment." Again, I am not a lawyer. I am doing this as a service because I feel like the conversations that we're having right now are only focused on employers mandating the vaccine. And any employer that would suggest that they're going to actually honor individual bodily autonomy is almost shied away from. So I think there needs to be a balanced approach to how the law is handling this, and a balanced approach to how the Constitution upholds civil liberties. But I am not a lawyer. Seek legal counsel on this as you're talking with your executive teams. There is legal precedent, recent legal precedent in the courts that would stand by you if you decided to stand with your employees and uphold the right to bodily autonomy.